There is a sentence almost every American knows. You have the right to remain silent. It appears in movies, on television, and in police dramas at the moment an arrest becomes a legal story. But that sentence did not come from a screenwriter. It came from a real case, a real interrogation room, and a confession that reached the United States Supreme Court. The case was Miranda v. Arizona, and it changed the rules of American questioning. In March of 1963, Ernesto Miranda was taken into custody in Phoenix, Arizona. He was brought to a police station, placed in an interrogation room, and questioned by 2 officers for about 2 hours. After that questioning, police had oral and written confessions. At trial, those confessions mattered. The jury heard them. The prosecution used them. Miranda was convicted. But the constitutional question was not simply whether a confession existed. The question was whether the government could use it. Miranda had been questioned while in custody. He had not been clearly told that he could remain silent. He had not been clearly told that anything he said could be used in court. He had not been clearly told that he could have a lawyer before and during questioning. That gap became the center of the case, not the crime scene, not the arrest, the room. A police interrogation room is not just a room. It has walls, a closed door, a table, and a chair, but it also has power. The person being questioned may not know the law. They may not know when to stop speaking. They may not understand that silence is not an admission. And they may not understand that words spoken under pressure can follow them into court. The Fifth Amendment says no person shall be compelled in a criminal case to be a witness against himself. But a right written on paper does not protect anyone unless a person knows it exists. That was the heart of Miranda. Before the government can use statements from custodial interrogation, the suspect must be warned. They must know they can remain silent. They must know their words can be used against them. They must know they can have a lawyer. And if they cannot afford one, a lawyer can be appointed. Only then can a waiver mean something. Only then can silence be a right, not a risk. In 1966, the case reached the United States Supreme Court. The decision was close. 5 justices formed the majority and 4 dissented. Chief Justice Earl Warren wrote for the court. The majority did not say police could never question suspects. It did not say confessions were useless. It said something more precise. Custodial interrogation carries pressure. That pressure can threaten the privilege against self-incrimination. So the law must place safeguards at the door before questioning begins. If those safeguards are missing, the prosecution generally cannot use the statement in its case. That became the Miranda rule, a courtroom rule, a police rule, and eventually a phrase in American culture. There is also a common misunderstanding about this case. Miranda won at the Supreme Court, but he did not simply walk away from the criminal system. His original conviction was reversed. The confession was excluded. Then Arizona retried him without the original confession, and he was convicted again. That fact matters because Miranda v. Arizona was never only about one defendant. It was about the line between investigation and compulsion. After Miranda, police departments across the country adapted. The warning became a card, a form, a training standard, and a sentence repeated so often that it entered popular language. But the warning is not magic. It does not apply to every conversation with police. It is tied to custodial interrogation, custody plus questioning. If there is no custody, the rule may not apply in the same way. If there is no interrogation, the issue may be different. Courts have spent decades arguing about the edges. What counts as custody, what counts as interrogation, and what counts as a valid waiver. The Miranda warning sounds simple. The doctrine behind it is not. The case did not end in 1966. In Dickerson v. United States, the Supreme Court reaffirmed Miranda as a constitutional rule that Congress could not simply replace by statute. But Miranda's power also has limits. In 2022, in Vega v. Teco, the Supreme Court held that a Miranda violation alone does not create a federal civil damages claim against an officer under Section 1983. So Miranda remains powerful, but it is not unlimited. It controls what can be used in a criminal trial. It shapes how police question suspects. It protects silence in the place where silence can feel most dangerous. The most famous line in American criminal procedure began with a confession in a small room. A suspect spoke. The government used his words. The Supreme Court asked whether that was enough, and the answer changed the country. The lesson of Miranda v. Arizona is not that guilty people never confess. It is not that police cannot ask questions. The lesson is colder and more important. A right that no one explains is a right many people cannot use. So before the questions begin, the state must speak first. You have the right to remain silent.